Hello everyone, this is Kulsoom Farhat Khan, a student of Institute of Law Nirma University and currently doing an internship at Amikus Qriae. So today I'll be discussing on the analysis of the legislation that is named Unlawful Activities Prevention Act 2019. So, first of all, let me talk about this legislation. What is it? Many of you might know it, but for those who do not know, the Unlawful Activities Prevention Act 1967 um, is a legislation was originally passed in 1967, which basically describes that it is basically on terrorist and disruptive activities prevention. So, till the year 2004, unlawful activities referred to actions related to cessation and cession of territory. It was only after the amendment of 2004 the Terrorist Act was added to the list of offences. The Act assigns absolute power to the central government, by way of which, if the centre deems an activity as unlawful, then it may, by way of an official gazette, declare it so. So that is how broad the powers of central government are under this act. So statistics say that as per National Crime Records Bureau, there were 922 cases reported under UAPA, that is Unlawful Activities Prevention Act, in 2016. Moving further, so we are here concerned with a recent amendment that was done to this act in 2019. So it was on 8th August 2019 that this act was given assent to by the President of India, the Amendment Act. So obviously, this Amendment Act made certain changes to the act. The primary change was made to Section 35 of the act. So, before the amendment, this provision, that is Section 35, only allowed organizations to be categorized as terrorist. With this amendment to Section 35 now, the government can categorize individuals as terrorists if it believes that the individual is involved in terrorism. Once the person is so categorized, their name will be added to the fourth schedule of the Act. So, this is the major change that the amendment has put in. So, yeah, there are a lot many features of the Act, Amendment Act, which needs to be um, considered. Firstly, so now the government is empowered to designate individual as terrorists, as I have said under Section 35, if the person commits or participates in acts of terrorism or prepares for terrorism or promotes or is otherwise in any way involved in terrorism. This has been done as it is seen that when a terrorist organization is banned, its members form a new organization to spread terrorism. So, this is the move. This is the reason why it has been done. The bill also empowers the Director General of National Investigation Agency to grant approval of seizure or attachment of property when the case is being investigated by the agency. Under the existing Act, the investigating officer is required to obtain the prior approval of the Director General of Police to seize properties that bear any connection to terrorism. It has been seen that many times the terror accused own properties in different states. In such cases, seeking approval of DGPs of different states become very difficult, and the delay caused by the same may enable the accused to transfer properties. And these are the reasons why the power has now been granted to the Director General of National Investigation Agencies to grant approval of seizure or attachment of property. Uh, Further, also now, it has empowered the officers of NIA of the rank of inspector or above to investigate cases. Before, it provided for investigation of cases to be conducted by officers of the rank of deputy superintendent or assistant commissioner of police or above. So now the rank has been lowered. The people who can now try the cases. As far as bail and arrest provisions are concerned, there has been no change made to the same. The International Convention for Suppression of Acts of Nuclear Terrorism 2005 has also been added in the second schedule through the amendment. Now, coming to what are the challenges that have been faced by this Amendment Act? So, the very first being that the overarching argument of the petitioners is that an individual may be identified as a terrorist without any judicial scrutiny and even before the commencement of a trial as per this act. Thus, they challenge the Amendment Act as being violative of right to equality, free speech, and life of the Constitution. As per the petition, the right to equality is violated since the provision does not provide any detailed grounds based on which one may be categorized as a terrorist. For this reason, the provision is manifestly arbitrary, as no reasons are provided with. The doctrine of manifest arbitrariness in brief states that if a law is made without an adequate governing principle and is excessive or disproportionate in nature, the same is manifestly arbitrary and thus antithetical to the right to equality. It was also submitted before the court through the petitions that have challenged this Amendment Act that the amendment goes against the right to dissent, which is a facet of the right to freedom of speech. Um, Decisions from Ramesh Thappar versus State of Madras and Makbul Fida Hussain versus Rajkumar Pandey were relied upon to drive home the importance of free speech and concomitant right to dissent. Article 21 is violated by this act as the right to reputation is an integral aspect of right to life. And this right is snatched away by the arbitrary exercise of powers under Section 35. Coming further, so these are the various provisions which very well state why this law is considered as a draconian provision. So there is a vague definition of terrorism to encompass a wide range of non-violent political activity, including political protest. It further empowers the government to declare an organization as terrorist and ban it. Mere membership of such a proscribed organization itself becomes a criminal offense. The powers are very wide and not restrictive, which can be used in an exploiting manner. It allows detention without a charge sheet for up to 180 days, and police custody can be up to 30 days. It creates a strong presumption against bail, and anticipatory bail is out of the question. It creates a presumption of guilt for terrorism offenses merely based on the evidence allegedly seized. It authorizes the creation of special courts with wide discretion to hold in camera proceedings and use secret witnesses, but contains no sunset clause and provisions for mandatory periodic review. So, these are the various provisions and various concerns why this law is so much opposed. It is empowering officials of Union Ministry to brand any person as terrorist without following due process. The name of such a person is included in the fourth schedule proposed to be added in the Parent Act. The only statutory remedy available to such a person is just to make an application before the central government for denotification, which is considered by a review committee constituted by the government itself. So the chain of bureaucracy, the corruption, the extent of exploitation that could happen and that is happening because of this act. The amendment does not provide any legal consequence in case an individual is designated a terrorist. The inclusion of one's name in the fourth schedule as a terrorist per se will not lead to any conviction, imprisonment, fine. So this is simply a power for the government to brand anyone as a terrorist. An official designation as a terrorist will be akin to civil death for a person, with social boycott, expulsion from jobs, hounding by media, and perhaps attack from self proclaimed vigilante groups following. So, this was an overview of how draconian this legislation is, and it should be pondered upon what steps our government is taking into uh, silencing the voice of the dissent. With that, I would like to end this presentation. Thank you very much for being a great audience.